The honorable Tricia make sure all your cell phones are turned on off or silent. Bow your head for a moment, silent prayer. Thank you. May be seated.
You've got control of all of this. Yeah, let's see, let's go to something, it's too times.
We don't have last.
Congratulations, by the way.
Commonwealth ready to proceed?
Yes, John.
All right. I am Judge Whitaker, and again, I don't know how you all do your court system down here. So been getting some updates on what we're doing, so I'll do the best I can. So we're Eddie Bowman, Michael Taylor, and Tyler White. Were they transported?
Yeah.
All right, let's go with Eddie Bowman, please. Yes. Thank you. Let's see. And, Michael Taylor's paperwork is in this, so let's go. All right, so Clinton Circuit Court, indictment number 26 CR2. And it looks like that we are on for final sentencing. All right, Mr. Turner, good morning.
Good morning, Judge.
Have you and your client had an opportunity to go over the PSI?
I have, Judge.
All right, any corrections that need to be made to it?
No,
Anything that you want to say on behalf of your client?
no, Your Honor.
Commonwealth have anything they want to say?
No, Your Honor.
All right. No legal cause having been shown, it's hereby ordered and adjudged. Then in indictment 26 CR2, Eddie Bowman is guilty of the offense. It is wanton endangerment in the first degree. It would be a sentence of 2 years. The PFO second degree is going to be dismissed. That 2-year sentence is going to be probated for a period of 5 years. The agreement was for it to be probated after he had served 6 months in jail. I'm showing he served 196 days. Is that
Yes,
correct?
Judge.
All right, so he will be placed on supervised probation at this time. Mr. Bowman, you will meet with probation and parole at least 1 day a month. They may call you in more often than that, but at least 1 day a month. Each time you go in there, there'll be a supervision fee you have to pay, and they'll be able to drug test you. Your conditions will include no new charges, no drugs or alcohol, meeting with probation and parole as directed. You will cooperate with them, make certain they know exactly where you live and work. They monitor you at both of those locations. Court costs would be
155.
155.
Yes, ma'am.
All right.
Judge, if I may, I would note also this is to run consecutive with,
Clinton 19 CR 41 and 22 CR 50.
yes.
All right. Is he going to be on probation on both of those?
Yes, Judge, that was, there was a motion to revoke, but yes, there's an agreement with the Commonwealth in those cases as well that his probation would be extended an additional 5 years on that.
How long does it usually do those start serving a court costs? $30 a month, starting 30 days from your release from custody.
Yes, ma'am.
All right. Anything else, probation?
I'll meet with him just for a second, Judge.
All right. Again, any questions, Mr. Bowman? All right. Good luck to you, sir.
Thank you, Judge.
You're welcome.
One time.
Michael Taylor. Thank you. Alright, so was there a mediation that occurred in this, Mr. Fuente?
There was, Your Honor.
Alright, and the agreement. It says upon a plea of guilty to wanton endangerment in the first degree, the defendant would receive a sentence of 5 years to serve. On a plea of guilty to criminal mischief first degree, the defendant would receive 5 years to serve. On a plea of guilty to arson third, 5 years, all to run consecutively for a total sentence of 15 years. On the service of 180 days after final sentencing, the Commonwealth would agree to short probation. Supervised for 5 years and reside in the state of Ohio and have no contact with the victim, Lisa Davis. Is that still good to go?
Yes, we are, Your Honor.
All right, Mr. Taylor, I need you to raise your right hand, sir. You swear or affirm the statement you're about to make be the truth, the whole truth, and nothing but the truth?
I do.
All right, put your hand up. I need your full name, please.
Michael Vincent Taylor,
And what is your birthday?
February 17th, 1984,
What are the last four numbers of your social?
2856.
Mr. Taylor, how far did you go in school?
I got my GED.
Have you ever suffered from any type of mental illness?
Yes, ma'am.
All right, tell me a little bit about that.
In the military, I suffered post-traumatic stress disorder, have anxiety, general. I've been diagnosed with bipolar type 2, I believe, and recently borderline personality disorder, ma'am.
Do you take any medication for that?
I take an antidepressant and a blood pressure medicine that helps me with my anxiety.
Okay, are you taking it now?
Yes, ma'am.
All right, are you taking it as prescribed?
Yes, ma'am.
All right. With the diagnosis that you just had and the medications that you listed, do you still believe that you understand what you're doing here today?
I think so, ma'am.
All right, you think so?
Yes, ma'am. I do.
All right, with that, if you were to have a question about something that I say or something that I do, would you let me know?
Yes, ma'am.
All right. So in this indictment, 24 CR 2, you had the following charges. It says on or about 27th day of October, 2023. In Clinton County, the above defendant committed first degree arson, a class A felony with the intent to destroy the dwelling of Lisa Davis. He intentionally poured gasoline on the front exterior, continued to pour gasoline in the living room, and then ignited the gasoline with a lighter. Charge 2, wanton endangerment first degree on the same day. Under circumstances manifesting extreme indifference to the value of human life, he engaged in conduct that created substantial danger of death or serious to Lisa Davis. Charge number 3 in Clinton County, same day, assault first degree, intentionally caused serious physical injury to Lisa Davis by means of a deadly weapon or dangerous instrument, or under circumstances manifesting extreme indifference to the value of human life. Charge number 4 in Clinton County, 27th day of October, 2023, criminal mischief first degree. No right to do so. He intentionally or wantonly defaced, destroyed, or damaged property belonging to Lisa Davis. Charge number 5, same day, Clinton County, criminal attempt to commit murder based upon the circumstances that were listed with the arson of first degree. Do you understand all of those charges?
Yes, ma'am.
You are currently represented by Mr. Poindexter. Have you had enough time to talk to him privately about the case?
I believe so, ma'am.
All right. Are you satisfied with the services he's provided on your behalf?
Good enough, ma'am.
All right, good enough. All right. Is there something that you wanted him to do that he didn't do?
I just wanted to stay in communication for a little more, but that's my only complaint.
All right. All right. So with that complaint, are you still willing to go ahead? You participated in mediation. Are you still willing to go ahead and enter this plea agreement?
Yes, ma'am.
So we're talking about a plea agreement. Before you plead guilty to anything, I want to make certain you understand what you're giving up. You do have a right to a trial by jury on this case. You'd be represented by counsel, and the Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth calls witnesses to the witness stand, questions them. Your attorney cross-examines those witnesses. You had evidence or witnesses you wanted the jury to consider before making a decision. He can subpoena witnesses and evidence to your trial. At that trial, no one can force you to testify at all. And if you're convicted, you have a right to an appeal. Those are all your rights. Do you believe you understand those?
Yes, ma'am.
If you plead guilty, you waive or give up all of those rights. So if you plead guilty, there is no trial. You plead guilty, there is no appeal. You understand that?
Yes, ma'am.
Did you go over a, motion to enter a guilty plea?
I did, Your Honor. It should be
Has he
attached.
executed it?
He has.
All right, so if you plead guilty to wanton endangerment first degree, Commonwealth's recommended 5 years. Criminal mischief first, 5 years. Arson third, 5 years. All to run consecutive, one after the other, so it's 15 years. When you come back here for final sentencing, if the Commonwealth, everybody's still in agreement, they will agree to shock probation after you've served 180 days after final sentencing. You'd be on supervised probation for 5 years. If you gotta live in Ohio and have no contact whatsoever with Lisa Davis, is that your understanding of your offer?
Yes, Your Honor.
Other than that offer, has anybody promised you anything else to plead guilty?
No, Your Honor.
Is anybody forcing you or threatening you in any way to plead guilty to these?
No, Your Honor.
Then I need to know, to wanton endangerment first degree, October 27th, 2023, do you plead guilty or not guilty?
Sorry, Your Honor. First degree?
Wanton endangerment first degree, October 27th of 2023, do you plead guilty or not guilty?
Guilty, Your Honor.
Upon the, excuse me, to criminal mischief in the first degree from that same date, do you plead guilty or not guilty?
Guilty, Your Honor.
And to arson in the third degree, same date, guilty or not guilty?
Guilty, Your Honor.
Mr. Poindexter, do you acknowledge you representing in this matter?
I do, Your Honor.
Have you gone over his rights with him, including any possible defense he could have? In talking to Mr. Taylor, has his decision to plead guilty been made knowingly, voluntarily, and intelligently, in your opinion?
Yes, ma'am.
Is it consistent with your advice to him?
It is.
We're just going to make that finding as well. The defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently, been represented by competent counsel. I'm going to accept the plea of guilty to those charges, and I'm going to set final sentencing. How far out is July? July the 9th. We're going to set sentencing for July the 9th. Mr. Taylor, between now and then, probation and parole is going to meet with you. They're going to do what's called a pre-sentence investigation report, all about you, your background, these charges, any other charges you may have had. They'll give that report to Judge Williams. He'll go over it before the sentencing on July the 9th. All right, and he'll use that report to make a decision as to whether or not to go along with the plea agreement. It was negotiated at mediation, so more than likely he should. So with that, cooperate with probation and parole in completing the report. Do you have any questions for me?
No, Your Honor.
All right, good luck. We'll be back in court July the 9th.
Thank you, Your Honor.
You're welcome. Robert, is it always the same? Never changes. Yes. All right, Tyler White. Mr. White looks like is on for final sentencing. Let's see, 26 CR 12. Right, Mr. Poindexter, have you had an opportunity to go over his PSI with him?
I have, Your Honor.
Any corrections that need to be made?
No, ma'am.
Anything that you want to say on behalf of your client?
No, ma'am. We've just asked the court to go with the offer.
Anything on behalf of the Commonwealth? No, Your Honor. Without legal cause, it's hereby ordered and adjudged in 26 CR 12, the defendant Tyler White is guilty. It looks as though he pled guilty to possession of a controlled substance, first degree, second offense, drug unspecified. It would be a 2-year sentence. He pled guilty to possession of a handgun by a convicted felon. For that, it would be 5 years. Those two run concurrently for a total sentence of 5 years to serve. He is to receive credit for the time that he has served. According to the PSI, it looks like 164 days. Is that correct?
It is, Your Honor.
Anything else? All right. Good luck to you, sir.
Judge, that's all I have. Can I see you?
Yes, you know.
Good seeing you.
You too. Is there a Charlotte Brown? Right. 25 CR 87.
You're right. I was-
Good morning, Mr.
Good morning, Judge. How are you?
If I could talk a little bit louder, it'd be all right, but other than that, what's up?
Judge, I think we need another date on this. Commonwealth has to talk to some folks on this one.
That's correct, Your Honor.
July the 9th, is that
We could have it set for negotiation day, it'll be July the sixth.
July the 6th?
And July the 9th.
Negotiation day on the 6th, pretrial on the 9th.
Yes, sir.
Ms. Brown, you are currently on bond. Make sure your attorney has good contact information for you. And you now know your new court dates, July the 6th and July the 9th. Stay in touch with your attorney, all right? Rachel Brumley. Twenty-six CR 40. It looks like it is on for a pretrial.
No, it's just report. Get behind it. Bring that into this. Okay.
So we're gonna be here at the border and see what this case, I believe, we're bringing it back to district court.
All right.
To attention.
I would go ahead, just to make certain it doesn't fall through the crack, and set it for pretrial on July the 9th.
Good idea.
Subject to the agreed order remanding it to district court.
It'll be fine.
Thank you.
You're welcome. Shirley Knatzer. 25 CR 74.
You're going over the PSI. If you can give us a couple of minutes on that.
Elizabeth Glidewell. Twenty-six CR 43.
Judge, we have a pretrial diversion for the court to consider.
You have that paperwork too, please. Give it to you. All right, Ms. Glidewell, I need you to raise your right hand. You swear or affirm the statement you're about to make to be the truth, the whole truth, and nothing but the truth?
Yes.
Let's put your hand down. I need your full name, please,
It's Gladwell.
and your birthday,
You already know.
the last four of your social.
8854.
Say that, 8854. All right, you're gonna have to talk up just a little bit louder so I can hear you. All right. All right. Ms. Glidewell, how far did you go in school?
12.
All right. So you graduated? Have you ever suffered from any type of mental illness?
No.
Are you currently under the influence of any drugs, alcohol, prescription medication?
And I think it's
All right, what kind of medicine do you take?
something. But they're like from the yard.
Okay. What do you take that for?
That's anxiety.
All right. Are you taking it as prescribed? All right. So you're taking medication. Do you still believe that you understand what you're doing here
Yes.
today? If you were to have a question, would you let me know? So in this indictment, 26 CR 43, you were charged with the following. Charged, it says on or about January the 19th of 2026 in Clinton County. The above named defendant, Elizabeth Glidewell, committed the offense of assault 3rd degree, a class D felony, when she recklessly with a deadly weapon or dangerous instrument or intentionally caused or attempted to cause injury to Sheriff Ricky Markham. All right. On charge number 2, on that same day, it's got to be listed as committing the offense of resisting arrest. And on the same day, it's got the charge of assault in the 4th degree. Do you understand those charges? All right, you are currently represented by an attorney, Mr. Shuffett, with Public Defender's Office. Have you had enough time to talk to him privately about the case? All right. Are you satisfied with what he has done on your behalf? All right. So we're talking about a plea agreement. Before you plead guilty, I want to make certain you understand what you're giving up. You have a right to a trial by jury on this case. You'd be represented by your attorney, and the Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth would call witnesses to the stand, question them. Your attorney cross-examines those witnesses. If you have evidence or witnesses about what happened out there on January the 19th, he can subpoena witnesses and evidence to your trial. At that trial, no one can force you to testify at all. And if you're convicted, you have a right to an appeal. Those are all your rights. Do you think you understand those? All right. If you plead guilty, you give up those rights. So if you plead guilty, there is no trial. If you plead guilty, there is no appeal. It's over and done. Do you understand that? He handed to the court a motion to enter a guilty plea, a 2-page document. It looks like he signed it. Did you do that? Yes. Right. All of the rights that I just went over with you, the right to the trial, the right to testify, they're on that front page under section 4. Do you have any questions about the motion or your rights? Right. So if you plead guilty to assault in the 3rd degree, the Commonwealth will recommend a sentence of 3 years, but they want you placed on pretrial diversion for 3 years. No, excuse me, 5 years. I misread that. 3 years pretrial diverted for 5. They'll dismiss the assault, 4, and the resisting arrest. Is that your understanding?
Yes.
Pretrial diversion, it's like probation. You'll meet with a probation officer at least 1 day a month. They may call you in more often, but at least 1 day a month. There'll be a supervision fee. When you go in there, they'll be able to do a drug test on you. So take your prescription medication in with you so they know what you are currently taking. All right? So, no new charges. If you do everything that you're supposed to do in 5 years' time, Ms. Glidewell, this case will be dismissed, diverted, and you will no longer be a convicted felon. Do you understand that? While it's pending, you are considered a convicted felon, so you can't have a gun, no firearms. Do you understand that?
Yes.
So, if the Commonwealth believes that you have violated the conditions of pretrial diversion, they'll file a motion and we'll come back to court. At that hearing, the judge would hear testimony. If the judge finds you've violated pretrial diversion, the agreement can be voided. You could be sentenced up to the 3 years in prison, and you would remain a convicted felon at that time. Do you understand that? So 3 years pretrial diverted for 5 years. Other than that offer, has anybody promised you anything else to plead guilty? Is anybody forcing you or threatening you to get you to plead guilty to this charge? to assault in the third degree, Sheriff Ricky Markham, from January the 19th of 2026. To that charge, do you plead guilty or not guilty?
Not.
I'm sorry. Guilty? Mr. Sheffield, do you acknowledge you represent her in this matter?
Yes, Your Honor.
Not over her rights with her, including
I
any
have, Your Honor.
defense. In talking to Ms. Glidewell, do you believe her decision to plead guilty has been made knowingly, voluntarily, and intelligently, in your opinion?
I do, Your Honor.
Is it consistent with your advice?
It is, Judge.
Court will make that finding as well. The defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently, which has been represented by competent counsel. I will go along with the plea agreement. It will be assault third degree, 3 years pre-trial to verdict for a period of 5 years under the same conditions that we just talked about, meeting with probation and parole, no new charges, no drugs, no alcohol. When I say no drugs, no prescription drugs currently prescribed, taking as prescribed, those are okay. Meet with probation and parole, cooperate with them. They need to know where you live and where you work. They can monitor you at both of those locations. Court costs in the amount of $155. Start paying within 30 days, $30 per month. All right. Ms. Glidewell, do you have any questions of me? Good luck to you. Meet that gentleman right over there. But Ms. Knatzer, has she gone over her PSI? Let's see, we've got 25 CR 74 Commonwealth versus Shirley Knatzer on for final sentencing. Mr. Cross, have you gone over her PSI with her?
We have no objections or exceptions to say.
All right. Anything you want to say on her behalf?
No, Your Honor, we believe that based on the court's prior ruling, we believe this is the appropriate resolution and just ask that the court recognize it.
Anything from the Commonwealth?
No, Your Honor.
No legal cause having been given, it's hereby ordered in the judge then in 25 CR 74 that the defendant Shirley Knatzer guilty is trafficking in a controlled substance. First degree, first offense opiates, class C felony. Commonwealth recommended a sentence of 7 years. Serve 120 days on home incarceration with the balance probated for 5 years, forfeiture of $5,000 to the sheriff's office. She's not currently under home incarceration, is she? All right. How long I'm going to ask you this question. When can she get signed up on the home incarceration?
We call him when we leave the courtroom, so it'll be no later than tomorrow, I'm sure, depending
All
on
right,
their
then.
schedule.
I will give 48 hours to sign up on home incarceration, no more than that. When she does do the 120 days on home incarceration, she'll be on supervised probation. She'll meet with probation and parole at least 1 day a month. Each time she goes in there, minimum supervision fee. She'll be able to be drug tested. So your main conditions will be no new charges, no drugs, no alcohol. Meet with probation and parole as directed. Cooperate with them. Make sure they know where you live. Make sure you know where they live, where you live, where you work. If you have a job, they'll be able to monitor you at both of those locations. This 120 days on home incarceration, you are still on probation. So if you violate anything while on home incarceration, you would be subject to having the probation revoked and the 7 years imposed. She'll have court costs of $155 payable at $30 per month beginning. I will go 30 days after release from home incarceration,
That's good.
since she has to pay for that. Anything else, Mr.
I
Cross?
don't believe so, Your Honor. Thank you very much.
Ms. Conetzer, do you have any questions?
There's a separate order regarding the balance of seized evidence. We can get that signed this morning. Get that done. Okay.
All right. Meet with the probation and parole officer. Good luck to you, ma'am.
I'll leave it right there.
Tyler Ledbetter. 26 CR 49. Can I get you to raise your right hand? Do you swear to tell the truth, whole truth, and nothing but the truth? Yeah. Put your hand down. Need your full name, please,
Tyler Ledbetter,
and your birthday,
9/16/91,
the last four numbers of your social.
8511.
Mr. Ledbetter and 26 CR 49. You were charged with, it looks like two charges. March the 12th through April the 27th of 2026, receiving stolen property, value over $10,000, and possession of burglary tools, a class A misdemeanor. Mr. Shuffett, were you previously appointed to represent him in district court?
We have been, Your Honor.
All right, I will go ahead and appoint a public defender to represent him in circuit court. You received a copy of the indictment.
I have not, Judge.
On the left side, I'm on the. Here's a copy of his indictment. Do you waive further formal arraignment and a plea of not guilty on his behalf?
Yes, Your Honor.
How far out do you want to go as far as a court date?
I think we normally go month to month, so.
Do you want, do you want the negotiation date or do you just want the pretrial date of July the 9th?
Both be fine.
All right, so we'll do a negotiation on 7/6, pretrial on 7/9. Mr. Ledbetter, you have made a bond. All right, be mindful of your bond conditions. All right, no new charges, no drugs or alcohol. Make sure your attorney has a good contact number and address for you so that you can go over the discovery before negotiation day. You have any questions, Mr. Ledbetter?
No.
All right, good luck to you. Let's see, Teresa Melton. Twenty-six CR 17, it is on for a pretrial conference.
Yes, Judge. I feel like we have a meeting of the minds, but we just are gonna wrap it up at the next court date. I don't think we need necessarily a negotiation day, but
Yeah, I just think we pass it to the next pretrial date.
So Ms. Melton, you are on bond and with the agreement of the parties, I'm going to pass this over to July the 9th for a pretrial conference. Make sure he has good contact number for you and an address so you can go over anything he needs to go over before that date. All right? All right. July the 9th. Jennifer Neal. So it looks like there is still an outstanding warrant on Jennifer Neal, so pass for service of the warrant. Kyle Norris, 26/4/25/117, both on for pretrial conference.
Your Honor, that's Mr. Garrett's case and he's just, yeah, that's what he just is informed.
All right. Tiffany Perkins, 26 CR 50. All right. Can I get you to raise your right hand? Do you swear or affirm the statements you're about to make to be the truth, whole truth, and nothing but the truth? All right, you put your hand down. I'm showing that you are on for an arraignment, so I need your full name, please,
Tiffany Lucille Perkins,
and your birthday,
10/7/87,
the last four of your social.
8629.
All right. So in 26 CR 50, the Clinton County Grand Jury charged you with, charge one was wanton endangerment first degree, March 2nd, 2026. Charge two was, it looks like DUI first offense with an aggravating circumstance. Charge three, possession of an open alcohol beverage container on that same day. All right. Mr. Shuffett, were you previously appointed in district court?
We have been judged.
All right. I'm gonna go ahead then and appoint you to represent her on the indictment. Here's a copy of it.
Judge, I would waive any further formal arraignment, enter not guilty, plead all charges, serving all pretrial motions. And adding guilty of the defendant.
So do you want to go just as a pretrial or do you want a negotiation date as well?
You should do both.
All right, so Ms. Perkins, I'm looking at a negotiation date of July the sixth. What time is that?
Nah,
9 a.m. And then a pretrial conference date of July the 9th. You are on bond. I need to make certain that you have given him a good phone number, good contact information, so that you can go over the discovery before your negotiation. All
Yes, ma'am.
right. All right, July the sixth, next court date.
Thank you.
You're welcome. Travis Powell, 26 CR 21. We did something? And I'm showing that this matter is on the docket for a pretrial conference. Anything to report, gentlemen?
Judge, we're still working on this one. He and I met this week and had an objective meeting. If we could put him on those negotiation and pretrial dates, I think this is one we should be able to work it out.
Yes, Your Honor, that's what we would agree to.
So your next court dates, July the sixth is the negotiation date. That's at 9 o'clock. All right, you are required to be here. July the 9th is a pretrial conference. So you are on bond. Make sure he has good contact information for you. And make sure you have both of those court dates written down. All right. Any questions? Desiree Riddle, 26 CR 36. Mr. Shuffett, anything to report on this?
Judge, we have a plea for the court to consider.
You want to go ahead and table it on up? Ma'am, can I get you to raise your right hand? Do you swear or affirm the statement you're about to make to be the truth, whole truth, and nothing but the truth?
Yes,
Get your hand down. Need your full name, please.
Desiree Riddle.
I was hoping that I sounded that correct. What is your birthday?
11/30/94,
The last four of your social.
5786.
How far did you go in school?
The 10th grade?
Have you ever suffered from any type of mental illness?
No.
Are you currently under the influence of drugs, alcohol, prescription medication?
No.
So in this indictment, 26 CR 36, looks like you just have the one charge, possession of a controlled substance, first degree, second offense. All right. It says on or about second day of February 2026, in Clinton County, the above defendant possessed methamphetamine, and this being second such offense. Do you understand that charge?
Yes.
You are currently represented by Mr. Sheffer with Public Defender's Office. Have you had enough time to talk to him privately about this case?
Yes, ma'am.
Are you satisfied with the services he's provided for you?
Yes, ma'am.
So he has tendered a signed Commonwealth's offer on a plea of guilty. Before I accept a plea of guilty, I want to make certain you understand what you are giving up. You do have a right to a trial by jury on this case. You'd be represented by counsel. Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth calls witnesses to the stand and questions them. Your attorney cross-examines those witnesses. If you have evidence or witnesses about what happened out there on that date, he can subpoena both witnesses and evidence to your trial. At that trial, no one can force you to testify at all. If you're convicted, you have a right to an appeal. Those are all your rights. Do you believe you understand those?
Yes, ma'am.
If you plead guilty, you waive or give up those rights. So if you plead guilty, there is no trial. If you plead guilty, there is no appeal. It is over and done at that point. You understand that?
Yes, ma'am.
He gave to me a motion to enter a guilty plea, a 2-page document. Looks like you signed that second page. Did you do so?
Yes, ma'am.
All of those rights are on that front page under section 4. Do you have any questions about the motion or your rights?
No.
So if you plead guilty to possession, first degree, second offense, the Commonwealth is going to recommend a sentence of 3 years. But they're going to recommend to the court that you be placed on supervised probation for 3 years, supervised, and an SSC evaluation to see if you need any treatment. If the evaluation says that you have certain needs of treatment, then you have to follow those. Do you understand that?
Yes.
Is that your understanding of the offer?
Yes, ma'am.
Other than that offer, has anybody promised you anything else to plead guilty?
No,
Is anybody forcing you or threatening you in any way to plead guilty to this charge?
no.
Then to the charge possession, first degree, second offense from the second day of February of 2026, methamphetamine. Do you plead guilty or not guilty?
Guilty.
Mr. Shuffett, do you acknowledge you represent her in this matter?
Yes, Your Honor.
Have you gone over her rights, including any possible defense she could have?
I have.
In talking to Ms. Riddle, do you believe her decision to plead guilty is being made knowingly, voluntarily, and intelligently, in your opinion?
I do.
Is it consistent with your advice?
It is, Judge.
Court's gonna make a finding that the defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently, been represented by competent counsel. I will accept the plea of guilty, and I'm gonna set sentencing over July the 9th, okay? Miss, probation and parole, is that enough time?
What now? I'm sorry.
Is July the 9th enough time? to
Yes,
get the
ma'am. Yes,
PSI?
ma'am.
All right, so I'm going to set sentencing over to July the 9th. Between now and then, Ms. Riddle, you're gonna meet with probation and parole and complete a report. That report's gonna be all about you, your background, this charge, any other charges that you may have had. All right, so you are on bond. Those bond conditions continue to be that you're not to have any new charges, no drugs or alcohol. It's a condition of your bond that you meet with probation and parole for that PSI and that you appear back here in court on July the 9th. If you violate any of those conditions, I would anticipate that the Commonwealth may ask that the sentence be a sentence to serve without probation. Do you have any questions?
No.
All right, meet with probation and parole July the 9th. Is there a Jason Savage? 26 CR 28? Anything to report on this, council?
Judge, he has a co-defendant which will appear momentarily on your docket. I'm conflicting Mr. Savage's case out. As of this moment, we don't have anybody. I was thinking we had somebody, but I think there might have been a hiccup in that negotiation. So I'd like to just set him over and hopefully have somebody by next court date.
Any objection from the Commonwealth?
No, you're.
So July the 9th?
Yes.
With that, Mr. Savage, you are currently on bond. Be mindful of your bond conditions. Make sure that he has a good contact number and address for you. If he gets an attorney, they may contact you before your next court date of July the 9th. All right, any questions?
No.
All right, July the 9th. Jada Shelton, 2638 and 2639. It looks as though both of these are on for a pre-trial, is that correct?
That's right, Judge. We had I think a productive, negotiation day on Friday. But if we could set this over for one more, I think we may,
Another negotiation day or
Both.
just a pre-trial? Okay.
yeah, both.
Commonwealth, any objection?
No, you're on.
All right. So in both of these cases, Ms. Shelton, you have a negotiation date of July the 6th. That's at 9 o'clock. You are required to be there. And then you'll have a pretrial conference date of July the 9th. Okay, you have any questions? Make sure he has good contact information for you. This is Mr. Dillon. I'm sure that the Cumberland County cases and Mr. Barrett's cases, well, it's not really long. Matthew Thrasher, 26 CR 32. Matthew Thrasher. He's on the out of custody list.
I'm checking with the jail judge to make sure they don't have it. Matthew Thrasher.
Yes, we, we may have done those.
So, he has posted bond, is that correct?
Yeah, he's out.
Yeah, he was here on our negotiation day and Judge, for some reason, I'm wanting to think we had an agreement to continue this to July because it was one of those deals, if he can pay off the portion of arrears that's being prosecuted, the Commonwealth is willing to dismiss and, you know, I can't.
Commonwealth's position, he is not here in court today.
Your Honor, it's my understanding that he's supposed to be here. We had it still said. Didn't do the agree order. Then pass it.
He agrees with regarding bonds to for pretrial.
Okay, well,
Under those circumstances, Mr. Shefford, I'm going to do a benchmark for failure to appear without bond. You can always bring up if he has a legitimate excuse as to why he's not here in the hospital or in custody or something. You can bring that before Judge Williams.
Judge, given the nature of the charge, would the court consider something like a $250 bond, which if posted could go toward the arrearage?
I'm going to ask the Commonwealth's position on this first and foremost. I said no bond.
Yes.
All right, and he said, would the court consider a $250 bond so that if he is arrested and he posted, at least it would go towards child support?
That's it. Like, the rearage is, it's like $25.
The arrearage, which would be 10% of what goes, so that's not bad.
Right now, no bond.
Yeah.
And the next one on my list was Naomi Tucker, but it's my understanding she was arrested last night and is in Russell. Oh. All right, sorry about that.
I was told that.
26 CR 35 then.
Judge,
Judge Williams.
if I could have if you could pass her, if I could have a moment with Ms. Tucker. I didn't see her before.
Let's go ahead. I will pass it to the side. Both of the other cases are Mr. Shefford's as well.
Next case.
Okay.
The next case is David Cross, so you can call it.
Oh, okay. Leon Weaver?
Yes.
Thank you, Larry. Very efficient.
I'm gonna talk about the other one. That's where till he gets those. So, I'm sorry, 25 CR 107, Commonwealth versus Leon Weaver. Anything to report?
Yes, Your Honor, we're ready to set this for trial.
Your Honor, that's contrary to what Mr. Stockton and I talked about, I thought we were just gonna bump it out a month and see.
It's, note that I'm always ready to set it for trial.
If it's set up far enough, that's fine, but it needs to be set up others.
How many days are we looking at as far as the trial date is concerned?
Like two.
Honestly.
I think we have to shut it down.
Same thing.
That's right. People know the crowd. For sure.
All right, we're looking at October the 26th and the 27th.
Your Honor, I've got a trial sitting in Green County the 28th. Let me see how.
Well, this will be over way before then.
Oh, God, no. No, it's an old case, you know, it's gonna be a booger.
All right, the 22nd and the 23rd of September.
Who's sitting down there the 18th? Your Honor, he has Mr. Weaver, point of explanation for the court of the Commonwealth. Mr. Weaver has some matters pending in Tennessee. They've all finally been consolidated. If those are resolved in a manner favorable to Mr. Weaver, we think we can work this thing out. If they're resolved in a manner unfavorable to Mr. Weaver, then it would be prudent to try to have we probably work it out anyway. So we're all treading water, so to speak, on these Tennessee cases. We finally got one attorney and all of them, a new lawyer, and kind of solve it. Basically, it's a couple of motions to vote over there. And looks like it ought to be rejected. So if we could put it out. I mean, I'll go back to that October 26th day if you want me to. It's going to make card on me. I don't want to do September, I think, or October 27th. That's just too close for stuff going on down there. Two old track, two cases in a row back to back.
November the 2nd and the 3rd. The Greene County case should be
I
done.
know, and here's what we've got. We've got a case sitting in Warren Circuit Court. It's going to take days. We're mediating on the 30th. I think it's 7.
So we're gonna set this for trial on November the 2nd and November the 3rd. And if needed as a continuance, you can file the motion.
Thank you.
For understandable reasons, I sure do hope it settles, everything.
All right. So, Mr. Weaver, you are on bond. All right. Make sure you comply with the conditions of that bond. And make certain that Mr. Cross has good contact information for you. So he doesn't have to run you down.
Yes, ma'am.
Thank you.
You're welcome.
Thank you, ma'am.
Stephanie Ray. 26 CR 23.
Judge, this is the co-defendant to the aforementioned Jason Savage. I'm gonna be keeping her case, but if we could just keep her on that same schedule that Mr. Savage got.
Negotiation and pretrial?
Yes.
Or just pretrial?
Both.
Alright, so Mr. Ray, you're gonna have two court dates, July the sixth at 9 o'clock, that's a negotiation day. July the 9th is a pretrial day, you are required to be in court on both of those days. Make certain he has good contact information for you, so you can go over the discovery before those court dates. Alright, any questions? No.
Judge, if
Back to Naomi
we can
Tucker.
recall Ms. Tucker.
We're back with 26 CR 35. Naomi Tucker, anything to report?
Judge, we do have an offer in hand that we negotiated Monday, or excuse me, Friday at the negotiation day. She had not received her discovery, so I provided a copy of that to her today. And I think it would be only fair to let her have a chance, because honestly, there's a video in the case that's pretty, well, it's the whole case. And I think it's only fair that she had a chance to look at that on her own. If we could reset this for our two dates, for the 6th and the 9th.
Any objection from the Commonwealth?
No objection, Your Honor.
Ms. Tucker, you have now two new court dates. July the 6th is a negotiation date, that's at 9 o'clock, and then July the 9th. So you're required to be in court on both of those days. Make certain he has good contact information. Does she already have a copy of that video to watch?
She's got it.
She's got it. All right, so go over that. Make sure you talk to him before the negotiation. All right,
Thank you.
you're welcome. As far as out of custody is concerned, I was only showing a Kyle Norris and a Candace.
I actually have one more, Judge.
Yeah.
Jennifer Cross. She wasn't custody at Wayne County, but she has since been released.
Both of the other ones that I was mentioning are represented by Ken Garrett. Has he made it his way here yet? No, not yet. All right. All right. So Jennifer Cross, 26 CR 16.
Yes.
She is now on bond. Any updates to report on this?
Judge, we have a misdemeanor plea for the court to consider.
Go ahead.
All right.
All right, Ms. Cross, please raise your right hand. You swear or affirm the statement you're about to make to be the truth, whole truth, and nothing but the truth. Put your hand down. Need your full name, please.
Jennifer Cross,
And your birthday.
12/16/77,
The last four of your social.
1756.
How far did you go in school? Good. Have you ever suffered from any type of mental illness? Currently under the influence of drugs, alcohol, or prescription medication?
No.
All right, so in 26 CR 16, you had the one charge, criminal possession of a forged instrument in the second degree. It says December 29th of 25. In Clinton County, the above defendant committed criminal possession forged instrument second, possessed a forged instrument with knowledge it was forged with the intent to defraud, deceive, or injure another. Do you understand that charge? Currently represented by Mr. Shepard. Have you had time to talk to him privately? Satisfied with the services he's provided on your behalf? I think back to the agreement. I want you to understand what you give up when you plead guilty. I know the Commonwealth is making a motion to amend this to a misdemeanor. I understand that. But I still want you to understand what you give up when you plead guilty, because there could be consequences to a plea to a misdemeanor. You do have a right to a trial by jury on this case. You'd be represented by counsel, and the Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth calls witnesses to the stand, questions them. Your attorney cross-examines those witnesses. You had evidence you wanted the jury to consider. He can subpoena both witnesses, evidence to that trial. At that trial, no one can force you to testify, and if you're convicted, you have a right to an appeal. Those are all your rights. Do you understand those? You plead guilty, even if it is to a misdemeanor, you give up all of those rights. So if you plead guilty, no trial. If you plead guilty, no appeal. It is over and done at that point. You understand that? Yes, sir. He gave to me a motion to enter a guilty plea, a 2-page document. Looks as though you signed that second page. Did you do so?
Yes, ma'am.
All of your rights are on that front page under section 4. Do you have any questions about the motion or your rights?
No, ma'am.
Commonwealth is going to move to amend this to a misdemeanor. It's criminal possession of a forged instrument, 3rd degree. If you plead guilty to that, they're going to recommend a sentence of 12 months. But they want you on probation for 2 years. And they have on here that the probation is to be supervised. Conditions: no new charges, no drugs or alcohol. When I say drugs, no illegal controlled substances. You have to have a current valid prescription. This is another concession on your part. You agree to have no contact with your mother, Edna Cross, or her property. And then you'll pay the court costs in this matter of $155. So if you plead guilty to the misdemeanor, those are the conditions. Do you understand those? Other than that offer, has anybody promised you anything else to plead guilty? Anybody forcing you or threatening you to plead guilty to this
No.
charge? To the amended charge, possession of a forged instrument, 3rd degree. Do you plead guilty or not guilty?
Guilty.
Mr. Shuffett, do you acknowledge you represent her in this matter?
Yes, Your Honor.
Gone over her rights, including any possible defense?
I have, Your Honor.
In talking to her, do you believe her decision to plead guilty has been made knowingly, voluntarily, and intelligently, in your opinion?
I do.
Is it consistent with your advice to her?
It is, Judge.
Court's gonna make that finding as well. Defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently, been represented by competent counsel. I will accept the plea of guilty to the amended charge. It'll be 12 months probated for 2 years. Probation is to be supervised. Again, no new charges, no drugs or alcohol. Meet with probation and parole as directed. No contact with your mother, Edna Cross, or her property. Court costs of $155. You need to start paying those at $30 a month, beginning 30 days. Do you have any questions for me?
Judge, we do have one issue. She was previously residing at her mother's property. She has no objection to the no contact moving forward, but most, if not all, of her belongings are still there. And
She's gonna have to get somebody, law enforcement wise, to go with her to that property to get that, because if there's any dispute as to what's hers and what's her mother's, then there will be a problem. So, she'll have to take that up with somebody, go talk to the sheriff's office to get somebody to go with her.
I think they've previously been unwilling to assist in that way, but maybe they will next time.
All right, good luck, man. See that gentleman right over there. All right. We started with some individuals. Let's go back to Kyle Norris. 117-26-4.
Morning, Judge.
Good morning.
Sorry, I'm late.
Mr. Norris, we are on now for pretrial on both of these cases. Anything to report?
Judge, what we have to report is we're still working through the restitution amount. I spoke with the Commonwealth. They're agreeable to moving this over for about 30 days to see if we can resolve that issue. Once that issue, I think, is resolved, I think the cases will resolve.
Your Honor, that is true, but this morning we just received notice that Mr. Norris has been violating his home incarceration. So we'll be asking for his bond to be revoked today.
What man? How was he supposed to be violating his home
He's
incarceration?
on home incarceration. He's only supposed to be going to a work, doctor, court, or church, and according to the report that we received, that he's been going to numerous locations throughout Albany, Kentucky, without any permission, according to the traffic.
Do you have a signed affidavit from the home
No,
incarceration?
we just received the fax this morning, just the report, not a signed affidavit.
I would request that it needs to be a signed affidavit and then attach that to a motion to revoke his bond and allow the attorney to have notice of the violation so that he can talk to his client and then set it for a hearing. But anyway,
Yes.
on that, if you are aware of what they are alleging, but I do believe that you are entitled to notice of what they are alleging. So, at this point in time, I would suggest if you have been doing anything, and I'm not saying you are, but if you have, you need to stop. Give your attorney at least something to argue. So, pretrial July the 9th.
Yes, sir.
Subject to motion to revoke bond.
Thank you, Judge.
You're welcome. Yes. Well, let me do one more. You talked to him. Yes, the grand jury is coming back with indictments.
What? You ready to roll?
Yes.
All right, you're ready. Actually, one for you. Yeah, Joe.
All right, grand jury, if y'all want to go ahead and have a seat. Who's my foreperson?
I
All right, can I get a copy of those indictments, please? As you all can tell, I'm not David Williams, so, with that. We just. Okay, that's Matthew Thrasher. Show me what that little one. Yeah, all right, so with this, any problems to report?
No, one of the cases, the paper is in there that would drop 2 charges due to the passenger admitting
Okay,
for the possession of marijuana in open container.
all right.
That was it.
Well, it was my understanding that, I have the Commonwealth Attorney come here for just a moment, please. What's the last time? Since. There, yeah. You wanna just mark that out. One of the indictments had Monroe County. So I'm going to have her to mark that out and put Clinton County. Can you have her initial that mark, please? Initial. So with that, I will go through and make certain everything is in order, just like with that. look at setting the bonds, issue the warrants, and the individuals will be served with their warrants. And the process will be started. It's my understanding that this is your all's last day. Is that correct? So with that, I know that both the Commonwealth Attorney's Office, the Clerk's Office, everybody appreciates the service of the grand jury. So thank you all very much. Do they do work excuses or anything about payment? That'd be Moses.
Yeah, of course, Thursday night it's been, so check that, but it's not the first of July.
All right. Thank you all very much. You're all free to go.
Thank you.
All right.
All right, the grand jury's out. Y'all can be seated. Give this to us. Mr. Garrett, we've had one about, and is Russell County on? All right, so, William Purdue.
Who are you needing, Judge?
William Purdue.
I don't see CTS Russell on there. He's not at Russell County, he's at CTS Russell.
So they are not,
Are they on there?
I'm not.
No, that-
All right,
it's not
so
Russell.
we'll pass that in case they come on. Mr. Garrett, are you ready on James Hurst?
Just give me like 2 minutes.
Okay. Is Eastern Kentucky Correctional Complex on there? They're not on there just yet either. What about Knox County? Right, see Charlie York on there. Rotor Correctional Complex. 2641, 2642. Okay. Anything to report on these cases?
Judge, we had a negotiation day, Friday, of course, in the intervening time period, Charlie was moved from Wayne County to the Rotor
Mr.
facility.
York, can you hear me?
Yes, ma'am. I do think we made some progress, specifically on the 26 CR 42 indictment.
The Clinton County Grand Jury returned another indictment against Mr. York today. It says March the 9th of 2025, trafficking, first degree, second offense. And March the 9th, possession, first degree cocaine. So, there will be a new indictment being
Well,
served upon
Is
him,
this an intervening and
March the 9th, twenty
well, that's the
twenty-five.
same dates as the dates in March
Yes.
in the 26 CR 42?
Yes, Your Honor, but it is, the drug is fentanyl, that one that we died on today, and we do need a new negotiation basically with the wrap all of them. Time it all up, but it wasn't even.
This possession charge is listed as cocaine. The other two are listed as meth and fentanyl. That's true.
So is this is a new number?
Yes.
Okay.
Just returned today.
right.
So he will need to, the warrant will be issued. He'll need to be served with that. Arraignments start the process and then have all three together.
Okay, what's the number? Could I get a copy? We
We
don't
don't
have it yet. Okay. So the arraignment will be next month,
Yes.
actually. Okay.
So these two cases here, set them over for a pretrial on July the 9th so that he can be arraigned on his new charge, and then you all can discuss further negotiation dates. And I don't know how long Mr. York will be at Rotor, if they'll transfer him somewhere else, so
Okay.
keep track of him. So if you get moved from somewhere other than Rotor, make sure you let your attorney know. So if he needs to get in touch with you about the new discovery on the new indictment, he can give it to you. All right?
Yes.
All right. Good luck.
All right. Am I free to go, Your Honor?
Yes, thank you.
Thank you.
All right, Spencer Althouse, I'm showing he's at Russell County Detention Center.
already got a pending case anyway.
25-100, 25-112. I was provided certain competency reports on him. My understanding, it's just to set a court date for the hearing. Is that correct?
Yes, Your Honor.
Judge, this is a case that kind of slipped through the cracks in my transition, taking it over from our contract attorney. I've met with Mr. Althouse now. I've kind of reviewed some discovery with him. I'm catching up. I don't know that we're ready to set a date, because I don't know, I haven't really explored the competency issue a great deal yet. And my understanding is KCPC has done their work, but it was over Zoom, and frankly, I find those aren't very thorough. So I mean, I don't know if we can really, I'm not really in a position to set a date. I may end up saying.
You may end up being able to stipulate to the competency.
Correct.
After you talk to him.
After I talk some more to him, correct. I just, at this point, I'm not able to really state a certain position on that just yet. Because.
Are you okay with going out just to do a pretrial on July the 9th to
Yes,
see
ma'am.
if he, I mean, it would at least save some time and effort if he's able to talk to him and stipulate to the competency. So, all right. So, Mr. Althouse, your next court date is going to be July the 9th. All right?
Thank you.
You're welcome, sir. There, it's Denise Evans. (26 CR 25). Miss Evans, can you hear me?
Yes, ma'am.
And it looks like that we are on for sentencing in this matter.
That's correct.
Judge, we have reviewed the PSI and find it substantially correct with no errors to report.
Not trying to cause problems or step on anybody's toes, but is the Commonwealth okay with proceeding with this, based on her statement, I did not intend to commit any crime? I'm pleading guilty so I can be with my family. I mean, she did plead guilty in front of Judge Williams, no matter what she says on the PSI. So I just need to know if you all are okay with going ahead, I will go ahead and proceed with sentencing. All right, so with,
Judge, just a little context to that. It's undisputed that she was found in a home that she did not have permission to be. So then.
it's whether or not she knew she had permission to be there.
Well, no, I mean, it comes down to intent. And of course, that kind of thing is in the gray area almost always. So she understands that she was in fact in a place that she was not, that she actually did not have permission to be at.
Probably should be very, very, very feel very fortunate that she wasn't shot.
Well,
She was located in a house she wasn't supposed to be. With that, like I said, I don't want to cause any problems, but the Commonwealth says that they are okay. With going along with this, if there's no legal cause, it's hereby ordered and adjudged that Denise Evans and 26 CR 25 guilty. It was, I think it was amended down to burglary in the 3rd degree. It'll be a 5-year sentence. She'll be probated, supervised for a period of 5 years. Ms. Evans, you will meet with probation and parole as directed. It should be at least 1 day a month. They may call you in more often than that. When you go in there, there'll be a supervision fee. There will also be able to do a drug test on you. So the main conditions of probation should be no new charges, no drugs or alcohol, meet with probation and parole as directed. Cooperate with them. Make certain they know where you live and where you work. They can monitor you at both of those locations. All right. And court costs are $155. Those are to be paid. It's my understanding, $30 a month, beginning 30 days from your release from custody. I'm not showing that she's being held on anything else. Is that correct?
I do not have anything, Judge.
All right, so as far as this case is concerned, she should be able to be released from custody. When does probation and parole want her to report to you?
I will contact her at the jail in just a few minutes before she's released.
All right, so Ms. Evans, probation is going to call the jail. They'll give you a date and time that you are to report to them. Do you have any questions?
No, ma'am. Thank you.
All right, you're welcome. Good luck.
Thank you.
Mary Russell. $25 CR 67.
We have the, good morning, Your Honor, Samantha Costello and Rebecca Dorr for Miss Russell. We have the originals, with Miss Russell's signature on them.
Just as a note, I want to make certain that everything is taken care of. I know that an attempt, a last minute attempt was made to have Miss Russell transported to
Yes,
court.
Your Honor.
And that wasn't able to be accomplished. So are you agreeable to having her enter her plea through Zoom?
We are, Your Honor, as long as Miss Russell is.
Ms. Russell,
Yes.
are you okay with doing this by Zoom?
Yes, ma'am.
Okay, all right. Yeah, so I need you to raise your right hand. Do you swear or affirm the statement you're about to make to be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. I need your full name, please.
Mary Elizabeth Russell,
And what is your birthday?
10/24/75,
The last 4 numbers of your social?
6106.
Ms. Russell, how far did you go in school?
I have some college hours.
All right. Have you ever suffered from a mental illness?
No.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
Yes.
All right. Prescription medication?
Yes, ma'am.
All right. What are you currently taking?
I'm on medication for multiple sclerosis, migraine,
What is
chronic,
that medication? What is the medication?
Kesimpta. It's a shot.
All right. Is the jail giving it to you?
Yes.
Any other medications?
Nortriptyline. It's for
Okay.
chronic migraines.
All right. The jail giving that to you?
Yes.
All right. Any other medications?
Zoloft
Okay.
for depression.
All right. And are they giving that to you as well?
Yes.
Okay.
What is the a B12 vitamin? There's another one and there's a couple of others and I'm not sure what they are.
Sometimes her medications have changed while she was in custody.
You're taking several medications. Do you believe, taking those medications, that you still understand what you are doing here today?
Yes, Your Honor.
If you were to have a question about something that I ask or something that I say, would you let me know?
Yes, ma'am.
So in this indictment, 25 CR 67, you were charged as follows. It says on or about August the 24th of 2024 in Clinton County, the above defendant committed the offense of murder, a Class A felony, with the intent to cause the death of Wesley Russell. She shot him 6 times and caused his death. Do you understand what you were charged with?
Yes, Your Honor.
Now, that's just the charge. You are currently represented by counsel in this matter. Have you had enough time to talk to an attorney privately about this case?
Yes, Your Honor.
Are you satisfied with the services that have been provided on your behalf?
Well enough, Your Honor.
Well enough. All right. Is there something specific that you wish would have been done that wasn't done?
Just that it was a few of the components that was explained to me could have been printed out and handed to me so I could have read over them more closely, because I was not able to have anything in hand to be able to read while in my cell.
Okay. With that in mind, are you still willing to go ahead and take this plea agreement? We're getting ready to talk.
Yes, ma'am.
Good. So, it's my understanding that there was mediation,
Yes, Your Honor, there was mediation last week.
and at that mediation, it was my understanding that the Commonwealth agreed to amend the charge from murder to manslaughter in the first degree. Is that right?
That's correct, Your Honor.
Commonwealth makes that motion?
Yes, Your Honor.
So the Commonwealth is moving to amend the charge of murder, which carries 20 to life, to manslaughter, Class B felony, 10 to 20 years. If you plead guilty to that charge, it's my understanding that they're going to recommend a sentence of 15 years. Is that what you understand?
Yes, Your Honor.
So prior to taking a plea of guilty, I want you to understand what you give up when you do plead guilty. You do have a right to a trial by jury on this case. You would be represented by counsel, and the Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth calls witnesses to the stand and questions them. Your attorney asks questions of those witnesses, cross-examines them. If you had evidence or witnesses about what happened out there in August of 2024, your attorneys can subpoena witnesses and evidence to your trial. At that trial, no one can force you to testify at all. And if you are convicted, you have a right to an appeal. Those are all your rights. Do you believe you understand those?
Yes, Your Honor.
If you plead guilty, even if it is to an amended charge, you waive or give up those rights. So if you plead guilty to manslaughter first degree, there will be no trial set. If you plead guilty to that, there will be no appeal from the conviction. It is over and done. Do you understand that?
Yes, Your Honor.
Did y'all go over a motion to enter a guilty plea with her?
We did, Your Honor.
Do you have that document?
Yes. It's the second one.
So I was just handed a couple of documents. And one of them is a motion to enter a guilty plea. And I know this is kind of difficult, but it looks like you signed it on that second page. Did you do so?
Yes, Your Honor.
All of your rights, the rights that I just went over with you, the right to the trial, the right to an appeal, they are listed on that front page under section 4. Do you have any questions of me about the motion or your rights?
No, Your Honor.
Again, the Commonwealth has moved to amend this to manslaughter in the first degree. If you plead guilty to that charge, Commonwealth will recommend a sentence of 15 years to serve. Now, this is considered a violent offense, so you're not going to be eligible for any type of probation. And you would serve at least 85% of that sentence before you would meet the parole board. Do you understand both of those?
Yes, Your Honor.
Other than that offer of 15 years to serve, has anybody promised you anything else to get you to plead guilty?
No, Your Honor.
Is anyone forcing you or threatening you in any way to get you to plead guilty to this amended charge?
No, Your Honor.
To the amended charge manslaughter in the first degree from August the 24th of 2024, do you plead guilty or not guilty?
To the amended charge,
The amended charge manslaughter in the first degree.
guilty.
Counsel, do you acknowledge you represent her in this matter?
Yes, Your Honor.
Have you gone over her rights, including any possible defense she could have?
Myself and Ms. Stewart did, Your
All
Honor.
right. I'm just asking one person.
Yeah, no, yes, yes. I wanted to say that because Ms. Stewart actually signed it with her, but we were both in the room going over it.
Do you believe her decision to plead guilty has been made knowingly, voluntarily, and intelligently, in your opinion?
Yes, Your Honor.
Is this plea consistent with your advice given to
Yes.
her?
Yes, Your Honor.
Of course, I'll make that finding as well. The defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently. She's been represented by competent counsel. I will accept the plea of guilty to the amended charge and we'll go to that sentencing for July the 9th. Ms. Russell, between now and July the 9th, probation and parole is going to come talk to you. We're going to go over, it's called a pre-sentence investigation report, PSI. All right, it's going to be all about you and your background. It's going to have facts about this case, any other charges you may have had. All right, you are to cooperate with them. That report then will be turned over to Judge Williams before you come back here for final sentencing. He'll use that document to make a decision as to whether or not to go along with this plea agreement. All
Yes,
right.
Your Honor. Yes,
Have
Your
any
Honor.
questions? Do you have any questions for me?
No, ma'am.
All right, July the 9th, her sentencing date.
Yes, thank you, Your Honor.
You're welcome. James Shelton. Twenty-five CR 97. Mr. Shelton, can you hear me?
Yes, ma'am.
Anything to report on Mr. Shelton's case?
Judge, I've met with Mr. Shelton and talked to Mr. Stockton. I think we're asking at this point for our July dates and then see where we're at that time.
Commonwealth have any objection to passing Mr. Shelton's case to July the 9th?
No, Your Honor.
Mr. Shelton?
Yes,
They're gonna-
ma'am.
They're gonna pass your case over to July the 9th for another pre-trial.
Okay,
Your attorney will be over to talk to you between now and then.
okay,
July the 9th.
okay, thank you.
You're welcome. Russell County, do you have any others?
That's all we have, ma'am.
All right. Thank you very much.
Thank you.
Wayne County, who do you have? Okay, microphone's still off. Still off. Okay, 1 minute. I was asking him his name and. Oh, okay. I didn't think it was Angela Frazier, so.
Should be unmuted.
There we go. Wayne County, I can hear you now, I think. Are you Mr. Jonathan Ray?
Yes, ma'am.
Well, that means you can hear me. We are on today, 26 CR 33. It is a pre-trial conference in this matter. Anything to report, Mr. Shepherd?
Judge, we're still working on this one, so I think we just need our July dates. And I was reviewing it yesterday with Mr. Ray. I don't think we have any labs in this one yet.
Mr. Chocolate is agreeable to another judge. I'm not sure about his labs, but obviously we'll try to, yeah, we'll try to check and see.
It's a DUI 4, and I think there was a blood test.
All right, so Mr. Ray, they are currently still waiting for information on the lab work in this case. So I'm going to give you 2 dates. The July the 6th is gonna be a negotiation date. And July the 9th will be a pretrial conference. So your attorney will be in touch with you about what's gonna happen on both of those dates, sir. Okay?
All right. Thank you, ma'am.
You're welcome. Nobody else has come to the front of the camera on this. Any of the ones that asked. I don't see CTS Russell, I don't see Shipping Declaration, I don't see notes. Who's ACRJ? Is that James Hirsch? Adair County?
We're here, Your Honor.
All right, do you have James Hirsch?
Yes, ma'am, I do.
All right, could you put him in front of the camera, please?
Yes, ma'am, one moment.
For the Cumberland County case. Are you Mr. Hurst?
Yes, ma'am.
So this is a Cumberland County cases, 22 CR 38 and 22 CR 13. And we have those.
Here he is coming and catching you.
So what I have in front of me on this is motion to revoke shop probation. Are you all ready to proceed?
Judge, one preliminary issue. There are some medical records that were dropped off for me in Cumberland County. I didn't pick them up on my way in. But it seems as though another basis of the motion to revoke is a non-negative test for methamphetamine. I probably am going to need to look into that a little bit to see what exactly a non-negative is.
I would assume a negative would,
All right, well,
a non-negative would be a positive, wouldn't you think?
well, normally that's not how it's phrased. I mean, usually it's phrased as a positive result. So what I would ask the court to do is permit us to bump this one more time. He is in custody. There won't be any prejudice really to the Commonwealth because he's currently in custody. I have attempted to negotiate with them for a bed date. We're not there yet. Obviously, they want to try to revoke. But if the court could give me a little more time on this, again, there's not going to be prejudice because he is in custody.
Mr. Hundley.
Which I hate to turn Mr. Gary down, but and I offer second chances for third and fourth chances.
I'm not asking, I mean, I'm not asking to agree to allow him to stay on shop probation. This is just give him a chance at least to look at the records before he proceeds. And it would be in front of Judge Williams.
All
Who
right.
I'd say might be more familiar with Mr. Hurst.
I'm sure that they both are.
Is it gonna be heard in Cumberland County?
I think it probably will be heard in Cumberland County. And James, I'll come and see you at the jail likely this afternoon or tomorrow afternoon.
All right, so Mr. Hurst, it's gonna be passed, what would the next Cumberland County date be? June 25th. It's gonna be passed to June the 25th. He is to remain in custody without bond until that time. Anything else on his cases?
No,
I was,
go ahead, James.
I was tested on when I was arrested. The probation parole come and tested me and I was negative.
Mr. Hurst, stop
I'm
talking.
sorry.
That
I'm
has to
sorry.
be the facts of the case. They're passing it over and you'll get your opportunity at that hearing.
All right. Thank you, ma'am.
You're welcome.
Is there anything else you need from us, Your Honor?
I'm not showing anybody else out of Dare County, so thank you very much.
Thank you.
I have an officer, Jeremy Gamer. Were you here for Mr. Hurst's case?
I was, Your Honor.
All right, so we passed it. The defense attorney needed more time to go over some documents that he has been receiving in this case. They don't have it resolved. It's still on for motion to revoke short probation, and it's gonna be heard on June 25th in Cumberland County.
Okay, Your Honor. May I be excused then?
Yes, you may. Have a good day.
You too, ma'am.
All right, let's go back to, it looks like Wayne County. The microphone is off. Wayne County, can you hear me?
Yes.
All right. Ma'am, what's your name?
Angela Brazo.
And as though we are here, it says review, but last thing I'm showing on here is a motion to revoke probation in this matter.
Judge, there was a motion to revoke probation and in the meantime, there had been a drug court referral and I believe an assessment has been made. Angela tells me that she got accepted in the drug court on Monday. I don't know independently from Angela whether that's accurate.
That's our understanding, and orientation is next week.
Do you all normally allow them out or do you keep them in giving orientation?
Until orientation.
All right, so orientation will happen and then she would be released back out on probation, but a condition successfully complete the drug court program. So you're gonna continue to stay in custody. They are going to come to the jail and do orientation with you. Once that is completed, you will be released. A condition of your probation will now be the successful completion of that drug court program. Okay? Anything else needed on her?
No, Judge, she'll just report to drug court as directed.
Once they complete that orientation, they'll give you the dates to go to drug court. You report to them.
And Judge, it may be, Angela, just so there's no confusion, it may be that you are released and asked to go somewhere for orientation. Okay, so.
Yeah, he told me Monday to be there at 11 a.m. The drug court guy did.
Well, if you are released, understand there is somewhere you have to be, so.
Yeah, he said 11 a.m.
If you have questions, call your attorney.
Okay.
Or probation and parole.
Okay.
All right, good luck, ma'am.
Thank you.
You're welcome. All right. Clayton County. Have they got it? Yeah, is that him?
No, I'll get him on.
Cameron Rodriguez.
David first.
Cameron Rodriguez, Clinton County.
We're getting just a second.
Arraignment, Your Honor, as well as revocation.
What?
Mr. Cross.
All right.
Yes.
Yeah, that's weird.
Is that him? I'm showing a Spanish interpreter on the Zoom meeting.
Yes, Your Honor, I'm here. I'm sorry. I was having trouble with my microphone.
That's all right. So I called the case of Commonwealth versus Kelvin Rodriguez.
Este es el caso de la Fiscalía versus Kelvin Rodríguez.
Sir, can you hear me?
¿Me puede oír, señor? Yes.
So in 26 CR 52, we are in court on an arraignment on that matter.
Entonces, para el caso 26R52, estamos aquí para una lectura de cargos.
Mr. Cross, do you represent him in that indictment?
Our office represents Mr. Rodriguez. We would acknowledge his identity, waive formal reading, and enter a plea of not guilty.
Su señoría, nuestra oficina representa al señor Rodríguez. Nosotros vamos a reconocer su identidad, vamos a renunciar a una lectura formal de la acusación y vamos a presentar una declaración de no culpable.
With that in mind, how far out do you want to go for a pretrial in this matter?
July 9th would be fine, Your Honor, next Wednesday.
¿Qué tanto tiempo necesita para programar su caso? El 9 de julio estará bien, su señoría.
I will put this on for July the 9th for a pretrial. And I will also put the other case, 23 CR 47, on for that same date to keep both of them together.
For negotiation day, Your Honor.
You want a negotiation date?
Well, we just, this time of year, we just kind of get together from, what's your normal thing?
July the 6th.
I think I'm somewhere else that day, so.
Voy a programar esto para el 9 de julio para una conferencia previa a juicio. También voy a programar el caso 23 CR 47 para el mismo día. ¿Necesitan una fecha para la negociación?
Yes or no to negotiation?
Yes, for the 9th.
So, Mr. Rodriguez, you're gonna have two court dates. One is gonna be July the 6th at 9 o'clock. It's called the negotiation day. And then you'll have a pretrial on July the 9th.
Kevin, I will be down to see you at the.
Entonces, señor Rodríguez, usted va a tener dos fechas de comparecencia. La primera es el 6 de julio a las 9 de la mañana. Se llama un día de negociación. Y después va a tener una conferencia previa a juicio el 9 de julio. Y su abogado dijo que va a ir a verlo a la cárcel.
Your court date, next court date is July the 6th.
Su próxima fecha es el 6 de julio.
And your attorney will be down to talk to you before then.
Y su abogado va a ir a hablarle antes de esa fecha.
Any questions?
¿Alguna pregunta?
No.
No.
Good luck, sir.
Buena suerte, señor. Would that be it for the interpreter, Your Honor?
Yes, thank you.
Thank you so much. Have a good one.
You too. I'm seeing, is it Amanda Gowan at the Knox County Detention Center? Amanda, that microphone is not on.
Your Honor,
Yes, sir.
regarding Miss Gowan, she's still on mute, but, there you go.
Say something, Amanda.
Can you hear me?
Yes.
Okay, sorry about that.
She has been appointed to the department. She's a co-defendant to Justin Smith. And we're currently still seeking conflict counsel for Ms. Gowan. Kind of the same situation we had with the other gentleman. We thought we had somebody and that didn't work out. So hopefully by the next date, we would have that in place.
Are you currently serving a sentence in Knox County?
No, ma'am, I go to get it resolved on the 8th. It's for child support. I get it resolved on the 8th.
I was just checking to see why you were there, so, July the 9th, to have conflict counsel ready for her.
Hopefully we will by then.
So Amanda, July the 9th is gonna be your next court date over here. They have to get a conflict attorney to represent you.
Okay, is there any way to get a bond reduction or anything? Like, I'm fixing to lose my home and my job that I have, and I know I don't have a lawyer, but I do have substantial proof proving that these allegations are not correct. I know I can't really give it to nobody without a lawyer, but I would ask the court to take that into consideration. So I just come off of a year and a half being homeless and just got my home and I'm about to lose it again. I would ask the court to, modify my bond where I can get out and keep my job and my home. I did turn myself in. I'm not trying to run from this. I would love to get it resolved, but.
All right, so again, I'm just sitting in for Judge Williams. And again, I'm not going to overturn his decision right now about bond. You'll have to have your attorney file a formal motion and put it in. Again, I'm not overturning his decision at this point. And so, the DPA is on notice. They need to get a conflict attorney ASAP. So he can file or he or she can file the appropriate motions for Ms. Gowan. Your next court date right now is July the 9th.
Okay, thank you. Thank you.
Back to the Clinton County Jail. Archie Boykin. 2631-2461. Anything to report, Mr.
Your Honor, he's got a PV and a pending case. We're still working on a potential global resolution if we could get those July dates.
Commonwealth okay with a negotiation date and a pretrial?
That would be fine, Your Honor.
All right, so Mr. Boykin, you're gonna have two court dates upcoming. One's gonna be July the 6th, negotiation date. See if the case can be resolved. It's at 9 o'clock. The next one would be a pretrial conference. If it can't be resolved, then they can set a trial date.
All right.
The attorney will be able to talk to you.
All right, thank you.
Cherry Britt. $26.48. Are you Mr. Britt?
Yes, ma'am.
All right. Let's be on the safe side. Raise your right hand. You swear to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down. Read your full name, please.
Terry Alex Britt,
And your birthday?
December 19th, 1995,
Last four of your social.
7633.
Mr. Shuffett, did you represent him previously?
The department was appointed in district court, yes.
I will continue that appointment as well. Here's a copy of his indictments. Do you waive further formal arraignment in a plea of not guilty on his behalf?
Yes, Judge. Judge, I would inquire about his bond. There is a co-defendant in this case, Mr. Ledbetter, who was previously arraigned and was out of custody. And I didn't know what the bond was for Mr. Britt.
It looks like it is currently 25,000, is that correct? It's currently a $20,000 bond. And, as I do in Pulaski, any motion regarding modification of the bond, I'm gonna ask. It's 10,000. Okay, because that bond amount there says 20, so it has been amended, 10,000. My apologies there, so. If you need a, bond reduction, file a formal motion and schedule it for a hearing. You require some type of proof before I do so, but with that, you want the July the 6th and July the 9th dates?
Yes, ma'am.
Mr. Britt, you're gonna have two court dates. One's July the 6th, it's a negotiation date, it's 9 o'clock. See if it can be resolved. Your attorney will have the discovery. So you all can go over it, see if it can be resolved. If not, you have a pre-trial date, July the 9th. That's good. Stanley Catron. Are you Mr. Catron?
Yes, ma'am.
We've got 2197, 21,120, 2184. That's looking like probation revocations and then an arraignment on 2653. Mr. Captain, raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
All I'm gonna ask you is your full name,
Stanley Robert Catcher,
your birthday,
July 2nd of 82,
and the last four numbers of your social.
1354.
1354. Mr. Sheffield. He's in custody on those other cases as well. I'm going to go ahead and appoint a public defender to represent him. There's a copy of his indictment. Do you waive any further formal arraignment and plea of not guilty on his behalf?
Yes, sure.
Do you want the July dates or?
Yes, please.
So, Mr. Catron, your attorney's now been appointed on this new case, and he's gonna get the discovery. You're gonna have two court dates. One's gonna be
Okay.
July the 6th at 9 o'clock. That would be for negotiation to see if the case can be resolved. All right, the next case, or the next court date after that is July the 9th, if it's not resolved.
Okay.
July 6th, July the 9th.
Judge, I was gonna make a request regarding bond.
Considering the probation revocations, I would be inclined to deny that.
I was gonna ask the court if the court would consider allowing the bond in the new indictment. I didn't remember the number there to stand also for the probation violations. He has pretty advanced liver condition. And is not doing well at all. I think probation pro, if not the Commonwealth, is aware of that.
If the Commonwealth and or probation and parole agree to it, you could submit an agreed order regarding any modification of his bond. Otherwise, it stays as is right now. Mr. Catron, July the 6th.
Okay, thank you, ma'am.
You're welcome. Billy Craig. 26 CR 13. Are you Mr. Craig?
Yes, Your Honor.
showing that we're on for final sentencing in this matter.
That's correct, Judge.
Have you been able to go over his PSI with him?
We have no substantive corrections to report to the court.
No legal cause been given why we should not now proceed with final sentencing. It's hereby ordered and adjudged in 26 CR 13. The defendant, Billy Craig, on a plea of guilty to the possession of a controlled substance first degree third or greater offense, he receives a sentence of 1 year. On the plea of guilty to possession of a firearm by a convicted felon, it receive a sentence of 1 year. Those sentences to run concurrently for a total sentence of 1 year to serve. Defendant shall receive credit for any and all time he has served on these cases, the 51 days per the PSI.
That's correct.
51 days toward a 1 year sentence, Mr. Craig.
Yes,
Good luck to you, sir.
thank you.
Good luck. Ricky Purdue. Mr. Purdue, can you hear me?
Yes, ma'am.
Was there an offer made and an offer accepted? Is that
There
correct?
should be paperwork in the file, I'm hoping.
Wait.
It's in there.
Motion to enter guilty plea signed, yes. Offer. It's here. Oh. Mr. Purdue, I need you to raise your right hand. You swear or affirm the statement you're about to make to be the truth, whole truth, and nothing but the truth?
I do.
Put your hand up. Need your full name, please.
Ricky Purdue,
And what's your birthday?
February 25th, 1981,
The last four of your social.
1284,
Mr. Purdue, how far did you go in school?
10th grade.
Have you ever suffered from a mental illness?
No,
Currently under the influence of any drugs, alcohol, or prescription medication?
no, ma'am.
So, Mr. Purdue, in this indictment, 26 CR 37, you had, looks like two, no, I think you had three. Three charges. It says on or about the fourth day of March of 2026 in Clinton County, the above defendant, Ricky Purdue, committed possession of a controlled substance, first degree, second offense. And this would have, we can try to see what this item was. Oh, methamphetamine. Count two is possession of a firearm by a convicted felon. Same day, March 4th, 2026, that you possessed, manufactured, or transported a firearm after having been convicted of a felony previously. Charge three is possession of drug paraphernalia. Do you understand all three of those charges?
The second charge was removed, ma'am.
That was what you were charged with on the indictment.
Oh, yes, ma'am. Okay.
Yeah, we start off with the indictment. Those were the charges. Do you understand them?
Yes, ma'am.
You are currently represented by Mr. Shuffett with the Public Defender's Office. Have you had enough time to talk to him privately about the case?
Yes, ma'am.
Satisfied with the services he's provided for you?
Yes, ma'am.
Talking about the agreement, I want you to understand what you give up when you plead guilty. You do have a right to a trial by jury. You'd be represented by counsel, and the Commonwealth would have to prove you guilty beyond a reasonable doubt. At a jury trial, the Commonwealth calls witnesses to the stand, questions them. Your attorney cross-examines those witnesses. You had evidence or witnesses you wanted the jury to consider before making a decision. He can subpoena both evidence and witnesses to that trial. During a trial, no one can force you to testify at all. And if you're convicted, you have a right to an appeal. Those are your rights. Do you believe you understand those?
Yes, ma'am.
If you plead guilty, you give up those rights. So if you plead guilty, there is no trial. If you plead guilty, there is no appeal. It is over and done. Do you understand that?
Yes, ma'am.
He provided to the court, Mr. Shuffett did, a motion to enter a guilty plea Two-page document, looks like you signed that second page. Did you do so?
Yes, ma'am.
All of those rights that I went over with you, the right to the trial, the right to an appeal, they're on the front page of this document under section 4. Do you have any questions about the motion or your rights?
No, ma'am.
Now, this is where we get to what the Commonwealth is offering. So if you plead guilty to possession, first degree, second offense, the Commonwealth is going to recommend a sentence of 1 year to serve. This sentence is to run consecutively to Cumberland Circuit Court case number 25 CR 67. And I was told that you'd already pled guilty in Cumberland County. And if 1 year consecutive would make it a total sentence of 6 years, is that your understanding?
Yes, ma'am.
Also forfeiture of the firearm. That's one last little bit. Other than that offer, has anybody promised you anything else to plead guilty?
No, ma'am.
Is anybody forcing you or threatening you in any way to plead guilty to this?
No, ma'am.
To the charge possession, first, second offense, methamphetamine from that date. Let me get that date here again. 4th day of March 2026. Guilty or not guilty?
Guilty.
Mr. Sheffield, do you acknowledge you represent him in this manner?
Yes, Your Honor.
You've gone over his rights, including any defense.
I have, Your Honor.
Talking to, and do you believe his decision to plead guilty has been made knowingly, voluntarily, and intelligently?
I do.
Consistent with your advice?
It is, Judge.
Court's going to make a finding as well. The defendant's decision to plead guilty has been made knowingly, voluntarily, and intelligently, been represented by competent counsel. I will accept the plea of guilty. When is he set for sentencing in Cumberland County?
I think 625 over there.
I just wondered if the probation office would be able to have everything wrapped up in one PSI. I'm making it too complicated, or should we just go to July the 9th here?
It might be easier just in order to keep a clean record in both counties, just to do
All right,
that.
so we'll do sentencing on July the 9th here in Clinton County. All right, so between now and then, probation and parole will come over to the jail. They'll do a PSI on you. It'll be all about you, your background, any other charges you've had, the circumstances of this case. When they come to the jail, cooperate with them and fill out that PSI and give them all the information that you have. Okay, July the 9th sentencing.
Yes, ma'am.
Is it Lucian Stevens? We have an arraignment in 26 CR 51. Who do we have at the Clinton County Jail?
That's Mr. Stevens.
What's your name, sir? All right.
Lucian Stevens.
Please raise your right hand. You swear or affirm a statement you're about to make to be the truth, whole truth, and nothing but the truth.
Yes, ma'am.
Put your hands down. You said your name's Lucian Estel Stevens,
Yep.
birthday,
August 21st, 1996.
the last 4 numbers of your social.
5171.
Mr. Sheffield, did you previously represent him?
Yes, Judge.
All right, I am going to appoint a public defender to represent you in this matter. Here is a copy of his indictment. Do you waive further formal arraignment and a plea of not guilty on his behalf?
I do, Judge.
Do you want the July dates for Mr. Stevens?
Yes, ma'am.
So, Mr. Stevens, you're gonna have 2 court dates. One's gonna be July the 6th, 9 o'clock. That's a negotiation day. The other date is July the 9th for a pretrial. So your attorney will get the discovery, go over it with you. You'll negotiate on the 6th to see if the case can be resolved. If it can, great. If not, come July the 9th, then you can set a trial date. Okay?
All righty.
On the 6th.
Thank you.
You're welcome. The other matters, the other matter, 23 CR 32, the pretrial diversion revocation will be put on for those same dates. Joshua Stinson. Sir, are you Mr. Stinson?
Yes, sir.
26 CR3, I'm showing that we are on for sentencing in this matter. Mr. Sheffield, have you gone over his PSI and everything?
Judge, we have, and we find no substantive corrections that need to be reported to the court.
It is my understanding in 26 CR3 that he had previously pled guilty. It was charged of criminal abuse in the second degree. He was placed, the Commonwealth recommended a 5-year sentence to be placed on pretrial diversion for a period of 5 years. According to the information on the PSI, his pretrial diversion was voided on May the 7th, and it was set for final sentencing on this date. And counsel advises that he has gone over the PSI with the defendant, finding no corrections. It's hereby ordered in the judge in 26 CR3 that the defendant Joshua Stinson is guilty of the offense of criminal abuse second degree. The sentence will be 5 years. Do you have any arguments you want to make as far as probation is concerned, Mr. Shuffle?
Well, Judge, I have talked to the Commonwealth regarding shock probation, and I do think that may be forthcoming. It's going to require a treatment bed, and that may be done rather quickly, but I'll reserve arguments for that time.
All right. So, Mr. Stinson, it'll be a 5-year sentence to serve at this point. Your attorney will talk to you about possibly filing for shock probation. It's not guaranteed that you'll get it, but he's in negotiations with Commonwealth to see if they can agree to it. But right now it's 5 years, credit for time served. Good luck, sir. Michael Thrasher, or excuse me, Mitchell Thrasher. Okay, so in 25 CR 84, it is on for a pretrial conference. I will advise the parties that he was indicted today. 1864, 1964. The date of birth and the social security number both match, so it's a possession, first degree meth charge, possession of drug paraphernalia from May the 18th of 2026. So as far as 2584, Commonwealth okay with going out to July the 9th, so he can be served with the new indictment?
Yes, Your Honor.
So Mr. Thrasher, there was a new indictment brought against you today. Possession is the felony, so they'll serve you with it and you'll be back in court. You'll be back in court on July the 9th for a pretrial matter and an arraignment. All right, sir?
Okay. I will say mostly for Mr. Thrasher's benefit that I had intended to make a bond motion. Mr. Thrasher's in poor health. He's been diagnosed with lung cancer, undergoing chemo. The jailer has spoken to me about if there's a way to get him out, so the county doesn't incur expense for these things.
Consider both of those are possessions, though.
They are.
Presumptively probation. I understand that. That'd be something that you need to talk with Commonwealth Attorney's Office about, because you've got one possession in 2025 and then you've got one in 2026. And just as an FYI, I mean, medical conditions don't do well with methamphetamines. So.
No question.
Right, July the 9th is your court date.
Judge, is there a copy? No, he was indicted today. There is no copy yet.
Not yet.
Okay.
July the 9th is your next court date, Mr. Thrasher.
Okay, thank you.
Camrick Wright.
Now.
24 CR 21. Mr. Wright, can you hear me?
Yes, ma'am.
And it's my understanding we are on for a motion to revoke pretrial diversion.
Your Honor, Cox and I agreed to send Camber to a rehab for a time to be determined. Did he let you all know to be I know, I would suggest that we just pass it as pending entry order for rehab in lieu of.
Mr. Wright, Commonwealth, I'm going to go ahead and pass this to the July the 9th date for the hearing. If there is an agreement to send you to treatment before then, they'll get Judge Williams to sign off on it.
He's been saying.
So much, Your Honor. All right, July 9th.
Get your app up. I'll be in touch. This morning, girl.
All right. Yes, you Christopher Young.
Am I good to go? Okay.
Yes, yes.
Still Christopher Young. Where's Christopher Young?
Just 1 minute, ma'am.
Yes, sir. CTS Russell and restricted public function over the.
Judge, I just asked to pass that to the next date. They didn't get on. That's probably the one you were going to defer to Judge Williams on, most likely anyway, I would think.
I've never seen one of them CTS Russell. I did order.
Well, it's a weird, it's kind of, it's.
I don't understand what CTS means. Russell
Well,
County's Russell County.
No, it's not, it has nothing, it's in Louisville.
Oh,
Judge,
It's
CTS is the Community Transitional something, it's a treatment center in Louisville. And they also house low custody inmates also. Kind of like, the Bluegrass Career Center in Richmond. They house low custody inmates. They let them go work while they're a state inmate. Is what that is.
well, on William Purdue, 25 CR 90, there was a motion for shock probation, so it would be passed to July 9th. They have not shut up on Zoom. And then Eastern Kentucky Correctional Complex did not show up this morning on a Mickey Shelton. So, that one would be passed as well to the July court date on both of those. All right, who do we have at the Clinton County Jail?
Christopher Young.
Mr. Young. All right, so 25 CR 118. Motion to revoke, is that correct?
Judge, it is, and I think we have an agreement in lieu of revocation, which is, for him to, enroll in and complete a long-term treatment that we will be getting for him, but the Commonwealth will have approval rights on.
Probation and parole. Does this work with you?
Yes, as long as Commonwealth's okay, I'm okay.
Yes, we agree to it.
What were the allegations of probation revocation? Test positive?
He absconded.
Oh.
Then as soon as he was arrested, he admitted to using for about the past 5 days.
All right, Mr. Young, you're very lucky that the Commonwealth is going to agree to allow you to go to treatment. So with that, is there a stipulation to the violations, Mr. Sheffield?
Yes, Judge.
On a stipulation to the violation, I will defer to the agreement of the parties. He is to remain in custody until an agreed upon treatment order is sent to the court for entry.
Correct.
So you stay there, go straight from the jail to treatment. Completion of treatment is now a condition of your probation. Right?
Christopher, there'll be somebody from my office in touch with you regarding the bed, and that will probably occur as early as Monday of next week.
All right.
I'm not showing anybody else at Clinton County. If that's true, Clinton County, you can log off. And I had one other Cumberland County case of Candace SIMAS. $25 CR 76.
Judge, we had passed this case to get an agreement in the case. We've got an agreement. We just need to put it in writing so the court can just put this to the next date for Cumberland County.
Commonwealth, is there an agreement?
The 2 years.
We don't know. So I know we do have an agreement, we just need to.
What's the next date in Cumberland County? Is it June the 25th?
I think that's right, Judge.
Is it okay? Go ahead, Commonwealth, June 25th. All right, June the 25th in Cumberland County. Make sure you stay in touch with your attorney between now and then.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
As far as the criminal docket, is there anything else need to be addressed? We can go off the record. Any particular order you want to go in?
We just have 5, Judge. Any way you want to go, we'll take it.
08CI 34, Samantha Thrasher versus Matthew Thrasher.
Okay, go ahead and read order. Okay. Judge, in this case, this is a arrears only, I believe, and we're asking that 1,000 be paid on or before July the 8th. Judge, and we've submitted a order electronically.
I will go ahead and, since he submitted it electronically, let Judge Williams sign off on that one. So, grant that and e-signed by Judge Williams, all right?
Okay, thank you.
The next one is 0974 Jesse Sloan versus Travis Sloan.
Judge, we've submitted an agreed order electronically.
So there's an agreement on that as
Yes, Your
well.
Honor.
So Judge Williams then can sign off on that agreed order. Number 3, Savannah Flowers versus Devin Gross.
Judge, in this case, the arrears is $800 and the last payment was $200 on January 27th, 2026. And we're asking that the non-custodial parent pay $500 by July the 8th of 2026.
500 by July the 8th. And is there an order submitted to Judge Williams?
Yes, Your Honor.
And I will go ahead and put on the docket entry for Judge Williams to sign off on that order as well. Jeremiah Shelton versus Haley Stewart, 21-8.
Judge, we've submitted an agreed order in that case electronically.
Agreed order to be e-signed by Judge Williams. All right, and Michaela Cash versus Casey Cash.
So this is a motion to establish child support. Not going to have Stephanie take a little brief testimony here about the income. Or we have some.
It's also on, it was on for, I'm looking at it, motion for custody, motion to bifurcate. I'm going to be passing that one as in the afternoon, but all right. I need you to raise your right hand. You swear or affirm the statement you're about to make to be the truth, whole truth, and nothing but the truth?
I do.
State your name.
Stephanie Witham,
Ms. Witham, by whom are you employed?
Clinton County Child Support,
And what is your position?
caseworker.
Are you familiar with the case we're hearing today involving Michaela Cash versus Casey Cash?
Yes,
And what is your involvement in this case?
I'm the caseworker.
Okay, and was a motion to establish child support filed?
Yes,
Okay, and how many children are there in this case?
one child,
And what is the age of that child?
3.
Okay, and did you run through the Kentucky child support system?
Yes,
In amount?
we submitted a worksheet,
Okay, and what did that worksheet come up with?
$238 per month.
And is that based upon the Kentucky child support guidelines?
Yes,
Is that also minimum wage?
it is for the non-custodial parent. The custodial parent submitted her wages from her employer.
Okay, but the amount comes out to 238 effect, and when do you want that to be effective? from?
June 1st.
The judge, we've submitted an order electronically on that one also.
You would put them on the docket sheet that the child support is to be granted at the rate of $238 effective as of June the 1st, electronic order to be signed by Judge Williams. Anything else?
That's it, Judge.
All right, thank you very
All
much.
right, thank you. Thanks.
Yes, please, until we get the other one. Mr. York, are we ready to go? All right, let's then, I'm gonna start calling the civil docket. Everyone, I'm looking at 17 CI 161, Brandy Carter versus Donald Carter. They're back there talking, let them talk, As long as they're not fighting, I'm good, okay? All right, Kentucky Farm Bureau versus Wesley Brumley, 19 CI 67, motion for summary judgment.
May it please court, AC Donahue on behalf of the Planet Kentucky Farm Bureau.
Anybody here on behalf of? It's got it listed as Jason Wayne Fairchild. Anybody here? Jason Wayne Fairchild. I almost thought that he might be in custody, but anyway. All right. Alright, so the requests for admissions have not been answered.
That's correct.
So those would be deemed admitted for purposes of the summary judgment. And as such, I do believe that you would be entitled to the motion for me to grant the motion for summary judgment. Is there a tendered, e-filed order on that?
There should be one already electronically filed, Judge.
All right. If you would go ahead and put on the docket, for Judge Williams that he signs that. Anything else, Mr. Donahue?
I have one other case. I'm covering for another attorney.
All right, and which one is that?
Your Honor, 25 CI 134.
Serve Bank versus Joshua Lavelle et al.
What's the motion, Mr. Donahue?
It is a motion to substitute plaintiff.
So I am showing that the order, Lakeview Loan Servicing LLC be substituted as the true party plaintiff. Judge Williams e-signed this on May the 12th.
That was signed May the 12th?
Yes.
Okay, I'll report that.
Motion to substitute plaintiff. Anything else, sir?
That's it.
All right.
Thank you, Judge. Good seeing you.
You too. All right, Philip, is it Dabelo versus Kimberly Hadley, 23 CI 55? Did they submit the agreed order to continue that? Anthony Wilson versus Carla Sutton, 23 CI 71.
Been withdrawn.
That has been withdrawn, okay. Taylor Britt versus Austin Britt, 25 CI 41. Judge Williams, it's been told to me that Judge Williams has recused and they are waiting for the assignment of a special judge on that matter. So that one will be reassigned when a judge is assigned. Taylor McGaw versus Stephen McGaw has 25 CI 121. That matter is being passed. Did you get a new date on that?
I suppose. We can't do it before, I guess that's all right. We may holler at you.
And then that would be the same as far as Michaela Cash versus Casey Cash is concerned. Motion for custody and bifurcation.
Your Honor, that was continued to next month's docket.
Thank you, Ms. White. And then lastly, Timothy Moons versus Ashley Moons. Again, it was going to be passed as well. Is that to the next docket?
Yes.
All right, let's go back. While you all were back there discussing, it was Brandy Carter versus Donald Carter. 17 CI 161.
Your Honor, I'm Nick Carter, not related, but representing Donald Carter for today's purposes. He's filed a motion essentially asking that the schedule change, but what he's really asking for, Judge, is for the child to be interviewed by the court. He's some information reported to him that he obviously can't say or be hearsay, but He's worried it's getting to be a borderline, unsafe situation for the child and wanting the child interviewed by the court, today if possible.
Your Honor, Mr. Donald Carter filed pro se motion. We filed a response asserting that what he wants is a modification. We've had orders entered within the last 30 days in this case. I think 2 years applies. And it ought to be summarily overruled because there's no affidavits at all with it. So we feel like Mr. Carter we think he ought to go ahead and overrule that motion today if he wants to refile it, or if our friend Nick wants to refile it. At some point in time, maybe there'll be an affidavit hearing, but we're not there yet.
And if I may, I'm sorry. I don't mean to
That's all,
speak up.
that's all right.
We did discuss, and I think both sides are in agreement that at the minimum, a friend of the court or GAL should be appointed on this matter.
Is that true, Mr. Cross?
Well, if you overrule his motion today, it would be premature to file to appoint a friend of the court regarding that letter. If the motion is passed and not overruled, then we would be in agreement to go ahead and appoint. Nick and I are in agreement.
I do believe based upon the response that was filed, that this court is going to overrule the motion at this time. One thing is it would be subject to refiling, but it does need to be done appropriately. I need it to be Mr. Donald Carter. All right, so with that, if you're going to file motions, you need to have an attorney file those so that they comply with all the rules established. All right, because if you don't, then they are subject to being overruled based upon that. So this motion, it's dismissed, overruled without prejudice. It can be refiled. If at any point in time you feel that your child is in any type of harm, I would say don't wait and file a motion and come to the court. You talk to the appropriate authorities. So with that, this motion is going to be overruled, subject to refiling. Hold that thought. Yes, sir.
My daughter is actually here out in the hallway. I would really appreciate if you could talk to her.
See, I can't do that.
She doesn't feel safe going back on.
And again, Mr. Carter, I can't do that. All right, this case is over. Thank you. Is David Burks versus Ashley Poland.
Your Honor, that was passed to another take motion.
All right. The only thing that I have left would be in Ray DP.
Your Honor, that's a confidential matter, Mr. Cross.
Yes,
All right. So if.
Approach, Your Honor.
Yes, you may.
Really simple because what we did.
Is this the one where he agreed?
Yeah.
And one of